Subscribe to our channel and hit the bell icon so that you know when live we go. Dear students, Rao's IAS Prelims Test Series 2021 is a complete testing and revision course for the upcoming prelims examination. The program will help you prepare for UPSC prelims through a step-up approach. It is a meticulously designed study plan to organize your preparation and keep you on track towards covering the prelims GS and CSAT syllabus extensively from NCERT to the advanced level. The goal of our Prelims Test Series 2021 program is to exhaustively cover all standard sources of study material, including NCERT, with a study plan to test you at par with UPSC level of questions, thereby improving your chances of clearing the prelims examination. To give multiple revision of the entire syllabus from the perspective of civil service prelims pattern. The test series program will also give you the final revision of all topics and themes before the examination through QIP videos and prelims compass notes. The QIP videos or Quality Improvement Program videos are for speedy revision of all important topics for the upcoming prelims examination. QIP videos are kind of crash course for the prelims examination. And prelims compass are 8 subject-wise prelims compilation of all static and current affair topics important for the upcoming prelims. Rao's IAS Prelims Test Series 2021 will include topics test, testing the concept of candidate. It will include thematic test on both the concept and the current affair of that particular theme. It will also include current affair tests covering the monthly current affairs. And there will be full-length test before the final exam to simulate you for the D-Day. There is a link in the description of this video. You can click on the link for registration and to also check out the demo QIP videos. Hello and welcome to Daily News Simplified. In this session, we are going to take up discussion on today's newspaper, The Hindu, Delhi edition, dated 3rd of December 2020. We shall take up articles important for the civil service examination and discuss them as per the demand of the exam. The articles that we are going to take up for discussion has been tabulated in front of you and the time stamping for the same has been given in the description section. Before we begin with the today's DNS session, let me just quickly inform you about the weekly answer writing session from the DNS. When you go to our eLearn platform, there is a tab Mains Assignment Questions. When you click on it, you will see the question that has been posted today, which is this. What is superconductivity? What are its various applications in our day-to-day life? To submit answer to this question, you need to click on the question. You will be taken to a new page. Then in the main thread, you go and paste your answer. You can either type and post in the dialog box, or you can write on a piece of paper, take the image in the portrait format and then upload it upwards. As you understand, mains examination is all about speed and you need to keep a track of it. So it is advisable that you write on the right top of your answer sheet the time that you have taken to answer the question. It will be really great if you can also mention the city and the location from where you are submitting your answer. It will help us to understand if DNS is reaching every nook and corner of our country. The utility of DNS for you and your learning experience will increase even more if you participate in this mains assignment questions. If you do timely submission, your answer sheet will be evaluated by the faculty of Rao's IAS. So get enthused and write the answer as soon as you can. This article is from page number 9. It has been titled, "There has never been a woman Chief Justice of India, says Attorney General." Attorney General Mr. K.K. Venugopal, he was invited by the Supreme Court to give suggestions to make judges more gender sensitive. The invitation and the brainstorming by the Supreme Court started in the backdrop of a judgment given by Madhya Pradesh High Court. The High Court of Madhya Pradesh recently passed a controversial judgment in which an alleged sexual molester was given bail. And the condition for granting bail included visiting his victim at her home and tying a rakhi on her hand and giving money and sweets to her and her sons. This matter was brought to the attention of Supreme Court by the women lawyers at the Supreme Court. 8 women lawyers at the Supreme Court has challenged this High Court's trivialization of victims' trauma. It is for the Supreme Court to judge whether this was trivialization or not. But definitely Supreme Court has gone into introspection mode, invited the Attorney General Mr. K.K. Venugopal, and Mr. K.K. Venugopal gave various suggestions. He stressed on the importance of making judges more gender sensitive, and he gave some suggestions like making some courses on gender sensitization compulsory in the law schools. Attorney General also took the opportunity to put out some data of skewed sex ratio in the higher judiciary. Attorney General brought it to the light of Supreme Court and general public that the Supreme Court has only 2 women judges out of the total sanctioned strength of 34. And there has never been a female Chief Justice of India. In the High Courts, there are presently only 80 women judges out of 1113 judges in all the High Courts. This comes to about 7.2%, which is too less. Attorney General also highlighted that there are presently 6 High Courts where there are no sitting women judges. These High Courts include Manipur, Meghalaya, Patna, Tripura, Telangana and Uttarakhand. If you go one step back from here, you will understand the problem lies in the skewed ratio in the senior lawyers, because they are appointed as High Court judges and from there they come to Supreme Court. The number of senior lawyers, that is skewed towards men. The same goes for number in the bar councils. There has never been a female chairperson or vice chairperson of any of the 12 bar councils that we have. Then there are very few females who are heading the law firms. This is about going down the ladder. If you go back in time, the situation was even worse. After independence, it took us 4 decades to appoint the first woman judge in the Supreme Court. Justice Fathima Beevi was the first female judge of Supreme Court of India. So definitely there is problem of skewed sex ratio in our judiciary. It needs to be corrected. It's very important to have good number of female judges in the higher judiciary, because judiciary serves the society. And if you're serving a society, if you're representing the society, that body has to be representative of the society. Otherwise, there will be no legitimacy. It is for the legitimacy of judiciary that women must be present in adequate numbers, ideally in the same ratio as there is ratio in the society. That is a body representing the society. Only then the jurisprudence in India would be more inclusive, equal and just. On various matters, it is important that the judiciary acts in a gender-sensitive manner. Judiciary must be bias-free. Various empirical studies have shown that even if there is 1 woman judge on a 3-judge panel or a 5-judge panel, the entire panel's decision-making in gender discrimination cases gets influenced. Many legal luminaries are of the opinion if the Supreme Court had 1 woman judge on the bench when the judgment against the Misuse of Dowry Prohibition Act was given, the judgment could have been very different. Then there are administrative reasons why women judges must be present in the court. Women litigants will feel more comfortable. They'll feel less intimidated in presence of female judges, especially in cases of sexual harassment. The judgment can also be more empathetic in case of sexual violence cases. So definitely there is great importance of having good number of women judges in India. And we already have seen that that is not the case. So the discussion from here can only go in one direction. What can be done to increase the women percentage in judiciary in India? In order to get to the solution, we have to get to the core of the problem first. You need to identify what are the reasons that are keeping women away from higher judiciary. Is it because of lack of systemic support? Is it because of lack of will of women? It is not the career choice in general, or there are other reasons. First of all, historically, women were not allowed to practice law in India. It was not male dominated, but it was male exclusive. The law forbade women from taking up law as profession. In early 1920s, this law was done away with by Allahabad High Court. And then Miss Cornelia Sorabji, she became the first woman advocate in India. She was not only the first woman advocate in India, she was also the first female graduate from Bombay High Court, and she was also the first woman to study law at the Oxford University. She was a social reformer and she did tremendous work in uplifting women in India. So historically, women did not have privilege to practice law in India, and the effect of that continues to be seen even today. Although the number of women have increased, but they are not matching with the percentage of male in the profession. And only very recently, large number of women are taking up to study law in India. But still, even in law school, if you look at the sex ratio, it is skewed towards male. Then the profession of law is such that women inherently face lots of problem in practicing the profession. There are various reasons for that, and even the litigants are biased towards women lawyers, and they prefer mostly male lawyers with whom they can socialize better and discuss their cases better. And if you're looking at the problem of skewed sex ratio in higher judiciary, if you go down the ladder, you will understand that there are problems with skewed sex ratio in legal practitioners. There are skewed sex ratio in law graduates. There are skewed sex ratio in the bar council. And there is also skewed sex ratio in lower judiciary. But the condition is not so poor. As you go from Supreme Court to lower judiciary, the sex ratio increases. So here is a critical question for you. We understand that the sex ratio in higher judiciary is poor, but what is the reason for that? Because solution to a problem will come from understanding the cause. If there is discrimination in the appointment, then there is a need for reservation, some affirmative action. But if law is not a popular career choice among women, then there is no need for reservation. There are other ways to increase the women practitioners. Because we know that the sex ratio in law colleges are also poor. So it could be the case that it is not a career choice for women. If that is the case, then there is no need for reservation. But if you see in your analysis that there is discrimination, then there is a need for reservation. So if a question is posed to you, should reservation be given in higher judiciary? Your answer would depend on your understanding of cause of lower number of women in higher judiciary. See, there are two things. It is true that lower percentage of women are law graduates. But it is also true that the percentage of female judges in lower judiciary is higher than higher judiciary. So there seems to be a case of gender discrimination. Collegium recommending names for higher judiciary have recommended very few female names. Now you cannot argue against this that there is no discrimination because women are of equal capacity as men. If the names for the higher judiciary from lower judiciary is coming more in favor of male, then there is a case of discrimination. Then there seems to be violation of right to equality under Article 14 and Article 15. Under Article 15(3), the state has the power to make special provision for women and children. And using this power, the state can make reservation for women in higher judiciary. India is also signatory to Conventions on Elimination of Discrimination Against Women 1979. And this convention envisaged removal of obstacles of women's public participation in all spheres of public and private lives. Entering into higher judiciary is a very, very important form of public participation. So as such, India is also obliged to remove this administrative difficulty of appointing women in higher judiciary. With these arguments, you can end up saying that yes, there should be reservation for women in higher judiciary. Or you can give an opposite answer. You can see the cause for lower number of women in higher judiciary as to be completely different. You can say that there are less number of women practicing law in India. There is nothing in the law to stop women from entering judiciary and become senior lawyers and judges. The number of senior lawyers in India are skewed towards male. Here there is no question of appointment, there is no role of collegium. As we have talked about, there are less number of women entering the law college, so it has to do with the interest of women in taking law as a career. And the examination for lower judiciary happens on a competitive open examination basis where there is no discrimination. The problem comes here when you go from lower judiciary to higher judiciary. And there are twin problems. One is a constitutional question. If executive and legislature start interfering in the matter of appointment, that can be seen as impinging on the independence of judiciary. So without disturbing the power balance among the organs of the state, what can be done is a regulatory and administrative reform from within the collegium, the initiation of which can be seen in the introspection of Supreme Court giving invitation to the Attorney General and discussing the issue of making judges more gender sensitive. Although certain states like Bihar and other states, they do give women reservation in the matter of employment and public services, but central government so far has not given reservation to women in any all India services. So giving reservation to women for appointment in higher judiciary will go against the set norms. I have given you arguments on both the sides. You have to be aware of them, and if a question comes, you have to write both. But in conclusion, it completely depends on you what you choose, whether to give reservation or not. This is a lead article from page number 6 titled Questionable Data, Little Room for Exuberance. You would be aware that National Statistical Office has released the data of growth for the second quarter of the year 2021. The number put forward is 7.5% contraction compared to 23.9% contraction in the first quarter. So it has raised expectation of a sharp economic recovery after the novel coronavirus pandemic and the national lockdown. But is this optimism realistic? Is it justified? The author says no, because the author says that there is little room for exuberance, little room for excitement, cheerfulness. The argument that the author has put forward in the article is this: the high frequency indicators like index of industrial production does not corroborate with the GDP estimate that NSO has put forward. The correction in index of industrial production is not proportional to the correction in GDP figure that has come out. The core sector has not expanded proportionally. In fact, from October to November, the core sector have contracted. Government expenditure, whether capital or current, has not increased compared to the last year. The GST collection has decreased from October to November. Our forex reserve is increasing, signifying that we are importing less. And if the imports are less, then the required material to increase the output will not be available. Then how come the GDP is doing so well? That is the question that the author has put up. Hence, in a way, this article raises concern over the flawed methodology for the GDP estimation. The article feels that the government is overestimating the GDP. In fact, former Chief Economic Advisor Mr. Arvind Subramaniam has suggested that the annual GDP growth rates during the last few years may have been overestimated by 0.36 to 2.5%. From the perspective of mains examination, let us see some of the flaws that are usually cited in the methodology of GDP estimation. First and foremost, it is pointed out that the data which is used for GDP estimation is flawed. In May 2019, NSSO, National Sample Survey Office, released a report. National Sample Survey Office now is National Statistical Office, which is formed after merging NSSO with CSO. In that report, which was titled Technical Report of Service Sector Enterprises in India, it was highlighted that almost 38% of the firms in MCA 21 are either out of coverage companies or they are closed or non-traceable. MCA 21 is our e-governance project of Ministry of Corporate Affairs for easy and secure communication with the corporates. And the data used to estimate the GDP comes from MCA 21 database. But the survey of NSSO has shown that 38% of the firms may be shell companies. And if we keep including these companies for the GDP estimation, then we would end up overestimating our GDP. The economists have highlighted that it is difficult to understand as to what extent our GDP figures are overestimated. But what is clear enough is that surely GDP is overestimated. Then the second flaw highlighted in the estimation of GDP is the measurement of economic activity in the unorganized sector. The economic activity in the unorganized sector is not measured directly by any means. Rather, the measurement is done by extrapolation on the basis of economic activity of organized sector. There is an underlying assumption that the economic activity in unorganized sector is coupled with the economic activity of organized sector. For example, suppose a jute industry in the unorganized sector is supplying the packaging material to some big firm, or some electronic work of lowest skill has been outsourced by a big electronic giant to the unorganized sector. In various ways, the economic activity which is happening in the unorganized sector is feeding into the work of organized sector. But the congruence or the correlation is not very strong. Sometimes generation and distribution of goods could be independent of the organized sector as well. For instance, in the aftermath of the twin shock of demonetization and GST, the ground realities clearly showed that it is the unorganized sector which got more adversely affected than the organized sector. Hence, there was a general decline in the economic activity in India during demonetization. However, according to the government estimate, the GDP growth rate for the year 2016-17, when demonetization happened, was 8.2%, which is considered to be the highest growth rate in the decade. How can that happen? The problem lies here in the extrapolation which is done for GDP estimation. If you talk about the method of GDP estimation, you can point out one more flaw. The flaw is related with the estimation of a state domestic product. The MCA21 database that we have talked about is used for estimation of a state domestic product as well. But MCA21 database does not exactly pinpoint the location of industries, various subsidiaries of the mother firm. It merely pinpoints to the head office of the company. Suppose the head office is in Bangalore, but various arms of that company could be working in Maharashtra, could be working in Chennai, could be working in Delhi. But when it comes to estimation, the entire economic activity will be considered to be happening in the state of Karnataka. So for some states, the GDP will be overestimated, and for some states, the GDP would be underestimated. But that won't be a problem for national level GDP estimation. But for state domestic product, this indeed is a flaw. The government has so far denied the claim that the underlying methodology is flawed. The official response is that government is following global best practices. The Economic Survey 2019-20 also has highlighted that the concern of overestimation of India's GDP are unfounded. If you look at these three problems, this is not a problem at all if you're looking at the national GDP. As far as extrapolation is concerned, it is not possible with the present ground level machinery to do direct estimation of all the economic activities. For a country of mammoth size like India, so much of government machinery will never be possible. But indeed, this is the area where correction can be done. This is an editorial article from page number 6 titled Castes Count. See, the state of Tamil Nadu has decided to set up a commission to collect caste-wise data of the population of the state. The decision has come up in the wake of pre-election agitation organized by Vaniyar community and parties representing the community. They are demanding 20% exclusive reservation in education and government jobs. See, the thing is, in 1987-88, due to violent agitation by the Vaniyar community, most backward class category was created. And by the virtue of this creation of new category, 20% reservation was given to the community. But over the period of time, Vaniyar community were dissatisfied because they were clubbed with hundreds of other castes in the most backward category. Increasingly these days, reservation is seen as a way for upward movement, socially, economically, and politically. Even though Supreme Court of India has declared that reservation cannot be demanded as a fundamental right, still the demand for reservation has only increased over the period of time. And it seems that the provision of reservation is going to stay, at least in the foreseeable future. It is in this context it becomes very important as to whether we should have a caste census to understand the status of various castes, even the upper caste, and then apply the tool of affirmative action of reservation. It is the promise of the Constitution to the citizens. It is mentioned in the preamble that the state will do socio-economic justice. For social justice, there are various provisions in the Article 14, 15, 17 and other provisions. For economic justice, reservation is seen as an important potent tool. At the same time, there are other issues in governance and administration. Government has to be objective. If there is no objectivity, then there is no question of justice. People will have the feeling of relative deprivation. Some section in the society will be seen to be favored by the state. And there is also importance given to data-driven governance. When there is no data regarding the socio-economic status of different section of population, the decisions on reservation are made on ad hoc basis. They are based on the prerogative of the government of the day. So the decision cannot be objective and there cannot be any justice. So that gave rise to the need of a caste census in India. In fact, the Ministry of Rural Development commenced the socio-economic caste census in 2011. But because of lack of reliability of the data collected, and perhaps because of the political and electoral implication, the caste portion of the socio-economic caste census has not been released yet. We have seen that Tamil Nadu has constituted a commission to collect the data concerning the socio-economic status. What the state can alternatively do is to take this caste portion of the data from the socio-economic caste census from the center, pertaining to its own state. The purpose of socio-economic caste census, as the name suggests, is to collect data regarding the social and economic status. So the census collects data concerning caste. It also collects data concerning educational status, and it also collects data concerning economic status. Percentage of population living below poverty line is also known through socio-economic caste census. If implemented properly, there are immense benefit that the socio-economic caste census can bring. It will first of all give us a picture, clear, that we have not seen yet. The economic status of various castes are not very well known. The governance works on the assumption that people of lower caste are subjugated, they are backward, and in general people of upper caste are well off. But a comprehensive caste-based data will give us the opportunity to work objectively and implement data-driven governance. States can plan the welfare schemes for most backward castes, and they can also do the same for economically backward people of the upper caste. You know that the caste-based mobilization along political lines have increased in the recent time. This also has led to increase in the demand for reservation in jobs and education. But as we have discussed before, it is essential to have data to decide how much reservation is actually necessary for a section or a given caste. If we do not have data, things will be ad hoc, and the promise of giving socio-economic justice to the citizen by the Constitution will remain unfulfilled. When the data of the census will be out and will be used in an objective manner, that will also give satisfaction to various groups, tribes and communities which are demanding for reservation. When those who will really need the provision of reservation will be given reservation, then the agitations may settle down. The census will also give the real picture in the changed circumstances. It has been documented that people from the upper caste, because of land fragmentation and agricultural stagnation, have turned poor. And it is alleged that some section in the lower caste have benefited from high rural wage. So the assumption that people from the upper caste are always well off and people from the lower caste are always downtrodden is not true. But you will have to work with this assumption as long as there is no quantifiable data. And that disability in governance will be done away with once we have socio-economic caste census. In long run, socio-economic caste census can actually be used as social registry information system. It will not just be a census, actually it will become a database for governance in general, for implementation of various schemes, for selecting the beneficiaries, provided that it is updated regularly. For these reasons, it is suggested that the caste census of 2021 must include castes and not just the category of OBC. That will in true sense help make our society casteless and just. There is a news article on page number 8, Isaac issue sent to ethics panel. The Speaker of Kerala Legislative Assembly has referred a breach of privilege notice against the Finance Minister of the state to Privileges and Ethics Committee of the Legislative Assembly. This is unprecedented. This has happened for the first time in the history of the Legislative Assembly that a privilege notice against a minister has been sent to the Ethics Committee for scrutiny. The charge against the Finance Minister is that he disclosed the details of a CAG audit report of Kerala Infrastructure Investment Fund Board even before it was tabled in the Legislative Assembly. Let us try and understand what needs to be understood regarding this news from the perspective of examination. First of all, ministers assume office after taking oath that they will not divulge any confidential information that comes to their notice except for official purposes. And on the violation of the oath, the governor has the authority to expel the concerned legislator. It's important for you to know that a CAG report has to remain confidential document till it is tabled in the Legislative Assembly. It is even printed in a printing press after an affidavit given by the printers that the report will not be leaked. The House, the Legislative Assembly, has the first right to know the details of the CAG report. So divulging the information which is there in the CAG report is violation of the right of the House. And violating the right of the House can attract 6 kinds of punishments. The House can just record the dissatisfaction. The House can give a warning. The House can reprimand the legislator. The House can impose penalty. The House can even expel the member from the Assembly, or the House can give jail sentence. Yes, the Legislative Assembly also has the power to jail a legislator or any person impinging on the right of the House. It has been done multiple times. Recently, the Karnataka Assembly jailed 2 journalists. This article is from page number 7, a looming health crisis. The article says that the world is busy dealing with COVID-19 pandemic. But many of us might not be aware or rather concerned of a silent pandemic which is taking roots and wreaking havoc. That pandemic is antimicrobial resistance. We dealt with the issue of antimicrobial resistance in the DNS dated 24th November 2020. In case you have missed it, you can use this DNS as a reference or the notes of today's attached PDF. We have come to the end of today's session. Now let us take up question for the day. Answer to yesterday's question is option C. All the kind of disabilities mentioned in the question are eligible for reservation under the Rights of Peoples with Disabilities Act 2016. Today's question is this. Consider the following statements with regard to GDP estimation in India. It is done by Central Statistics Office. Statement 2. It does not directly measure the economic activity of the unorganized sector. Statement 3. MCA 21 is used for estimating both the national level as well as state level GDP estimates. Which of the above is are correct? 2 only, 1 and 2 only, 2 and 3 only, 1, 2 and 3. With this we have come to the end of the session. Thank you very much for being with me for half an hour. I hope it was worthy for you. Goodbye. Take care.